Hey, so I'm a college athlete, big time star, play football in California, and all of a sudden my name and identity are used to sell cars. Is that okay with the NCAA? Of course not, but it might be okay in California pretty soon. Stay tuned. So, if you turn on any screen, you see you're almost inundated. You want to watch a video, you're going to get a little ad in front of it beforehand. And that ad may include people. It may include a star. It may include a musician. It may include an athlete. It might be selling a product. All of those things are contracted through something called the right of publicity. Individual public figures have a right to essentially own the property that is their endorsement value, the use of their identity, their name, their likeness, their image to sell products. Now you can actually, if you're not selling a product and you want to say good things, bad things, or whatever about public figures, the First Amendment protects your right. You can do unauthorized biographies. You can say all sorts of things that are critical of public figures. That's your free speech right. But you can't take a public figure's identity to sell a product unless they give you their consent. So that's what's called the right of publicity. That's the framework now that is being challenged by college athletes. Now this has been going on actually for a while. There's an O'Bannon Supreme Court case a number of years ago featuring a UCLA basketball star named Ed O'Bannon, who is challenging the fact that the individual recognized identities of college athletes was appearing in a number of video games. And he argued that I should be able to get my money. If I wasn't a college athlete, I could absolutely sue for right of publicity or demand that I be paid. But what the courts upheld is that under the NCAA's guidelines, its amateurism, its eligibility standards, if someone exercised what would otherwise be their right, they could lose that status in the NCAA. And the courts have upheld that for a variety of reasons and under a variety of challenges. So that's sort of the lay of the land at the moment. I don't really think it's right, but that's where it stands. But recently, in California, the legislature there has enacted a bill. Now, it hasn't become law yet. It's working through various committees, but it is making progress. And if the bill becomes law in California, it will actually change things such that if a college athlete based in California wants to use his name or likeness or identity in an endorsement situation, he or she can do so without violating the NCAA's rules. Now this is clearly, it's already brought people out who think this is going to be the death of amateurism, as if there is any amateurism left in college sports, who knows. And it's going to get challenged and it may get court challenges. So it's a long way from happening. But what I think it tells us is that one of these basic rights that we have as people is the rights of people are always sort of fighting to get out. In this case, the screen lawyer is keeping a close eye on this because unlike copyright law, which is the same throughout the country, the right of publicity laws vary from state to state. They basically have the same set of regulations and rules, but they are creatures of state law. So California could change its law in this situation, and then the NCAA would have to decide what it's going to do to its member institutions who are there. Who knows where it's going, but let's keep an eye on it. Like all things with the screen lawyer, we want to know what's going to happen when something ends up on a screen. Thanks, take care.